Good morning. Only few days left for your All India Bar examinations. Therefore, some 5 questions or more may be asked so far. The important starring judgments of Supreme Court in respect of Constitution of India. See, A.R. Abdul Rahman Antule versus R.S. Nayak. Abdul Rahman Antule was Chief Minister of Maharashtra. Therefore, there was a case which was initially quashed, and later on, the first time Supreme Court has tendered unconditional apology, claiming that the earlier judgment was erroneously verdicted. But however, they said, just like 482 CRPC, Supreme Court has said under Article 142 Constitution of India, Supreme Court has inherent power to rectify their mistakes. So, A.R. Abdul Rahman Antule versus R.S. Nayak case is dealing with the inherent power under Article 142. So, do not confuse with 482 CRPC inherent power and Article 142 says, Article 142 says, whatever the decision of the Supreme Court is a law binding all over India. Then Air India versus Nargis Mirza. Air India versus Nargis Mirza, wherein a woman was denied continuation of air hostess. So first empowerment, woman empowerment was restored. Then All India Judges Association case are dealing with the collegium. Then Balaji versus State of Mysore. Balaji versus State of Mysore. Therein intelligentsia difference. Intelligentsia difference. That means reasonable classification was decided. Bennett Coleman during emergency, Indian Express was disturbed. Therefore, they went to Supreme Court. So, newspaper rights are upheld as fundamental rights. Bennett and Beriberi Union. This is 1960 case. Beriberi is a small island, just like Kachatiu, which was given to Bangladesh, to East Bengal, that under the control of Pakistan. That since we follow Westminstership without getting approval of the Parliament, the seceding, the Beriberi found illegal. Therefore, Beriberi was still with India. And Bijoy Emmanuel, thereafter Cooper versus Union of India. Cooper versus Union of India deals with ordinance. Whether the validity of ordinance, whether the legislature or the state government or union government can continuously issue ordinance one after another. Then D.K. Basu case, where guidelines were given. D.K. Basu case, what all are the mandatory guidelines, mandatory direction instructions to the police at the time of arrest. That D.K. Basu case was subsequently incorporated by amending the Code of Criminal Procedure. Devadasan case belonging to scheduled caste issue. Then Gaurav Jain regarding prostitution, rehabilitation of arrested prostitution. Gyan Kaur case, where attempt to commit suicide was discussed. Golaknath prospective ruling, because after 13 years, 12 years, the Supreme Court, by descending with the earlier judgment, Sajjan Singh case and other cases, held that amendment is also law. Earlier they say amendment was not law. Then subsequently in Golaknath case they say amendment is law. Then Husainara, that's the Home Secretary case. Pre-trial bail. Indira Gandhi versus Raj Narayanan case, wherein Indira Gandhi's official secretaries found canvassing for Indira Gandhi. Her election was set aside and by the Allahabad High Court. Then they went to Supreme Court and some judgment which according to me is not acceptable. Indira Sahani case is dealing with creamy layer. Kartar Singh are dealing with president's power considering the death sentences. Kesavananda Bharati, you must concentrate on Kesavananda Bharati case because Kesavananda Bharati case is permanently decides about basic structure of the constitution. M. Karunanidhi versus Union of India, Pith and Substances, law of inconsistency was discussed. Minerva Mills case is subsequent to Kesavananda Bharati case, where after Indira Gandhi a declaration of emergency brought so many amendments to the constitution, and one was that this should not be challenged before the court of law. All these things have been struck down by following the Kesavananda Bharati case. So Minerva Mill case was subsequent case. Volga Telis is about a gas tragedy where absolute liability was fixed. See, so far liabilities are concerned: constructive liability, strict liability, absolute liability, para parentis. Paramananda Katara case, wherein the Supreme Court held that the private doctors should not hesitate to attend and give first aid for accident cases, because subsequently they can forward the patient to approved government hospital. That was Paramananda Katara. Then S.R. Bommai case may also be one of the questions. S.R. Bommai case, wherein the state assemblies were dissolved, en masse state assemblies, near about 7 state assemblies ruled by the opposite political party were dissolved. That was challenged before Supreme Court. Some guidelines were given. State of Madras versus Chambagam Durairajan. It's a case wherein first case of the constitutional validity under Article 14, where this Chambagam Durairajan belonging to Brahmin community was denied admission in medical college, and therefore they stuck down for having that said provision discriminate and did not give equality of law and equal protection of law. Therefore, after that, State of Madras with Chambagam Durairajan, Article 14 and 15, 16 were suitably amended. P.K. Rai, A.K. Gopalan case are about detention laws about detention law, two starring cases, A.K. Gopal and P.K. Roy case. Vellore Citizens Welfare Forum case deals with water pollution. Visaga definitely may be asked. Visaga deals with 100% protection to women and probe about women's harassment. G telephones case, extension of authority under Article 12 of the Constitution of India. Though GTV film company is a foreign company, the Supreme Court held that since they are dealing with affairs indulging in public in en masse, they said they may also be considered as authority. I hope you understand. Best wishes.